In the UK, we hold freedom of the press in high regard. It keeps citizens informed, holds the powerful accountable, and drives the public debate. But here's the catch. That same press has the duty to respect individual rights, especially the right to a good reputation. So, where's the balance? When does reporting in the public interest turn into harm? And what can you do if it happens to you? Let's talk about the topic that sits at the heart of democracy, but sometimes stirs controversy. When does a free press cross the line into defamation? A free press is considered a cornerstone of democracy, giving media outlets the independence to report on matters of public interest without censorship. In the UK, freedom of expression is protected under Article 10 of the European Convention on Human Rights, which has been adopted into UK law. However, freedom of expression is not absolute. It is subject to restrictions necessary for protecting individuals' reputations and rights. Media organisations are governed by regulatory bodies such as Ofcom, which regulates broadcast media in line with standards of accuracy, fairness and decency. IPSO, Independent Press Standards Organisation, which oversees print and online publications and enforces an editor's code of practice which includes standards for accuracy, privacy and anti-harassment measures. These bodies ensure that press can report freely while maintaining ethical standards, thus protecting the public from harmful or false information. Journalists and media outlets are often caught between reporting the facts and the risk of defamation claims. One wrong move and they could find themselves on the wrong end of a costly lawsuit. This can lead to self-censorship, where journalists are hesitant to publish stories that might be contentious or controversial for fear of being sued. This can have a chilling effect on the free press, preventing important stories from being told and silencing voices that need to be heard. Defamation refers to any false statement that harms a person's reputation. It can be divided into two types. Libel, defamation in a written or published form, example articles, books, social media, posts. Slander, defamation is a spoken form, example verbal, statements or broadcasts. Under the UK's Defamation Act of 2013, for a statement to be considered defamatory, it must 1. Cause serious harm to the reputation of the claimant, 2. Be shown to be false or misleading in a way that harms the claimant's reputation. The Act provides several defences for publishers, including the public interest defence, which allows journalists to publish statements that might otherwise be defamatory if they are in the public interest and responsibly researched. A journalist or publication may unintentionally or intentionally cross the line into defamation when they publish false information that harms a person's or organisation's reputation, they fail to verify sources leading to untrue or misleading content, they use sensational or inaccurate headlines that misrepresent facts, they make statements that cannot be justified by public interest or honest opinion. One of the high-profile cases involved a defamation claim by former Irish Prime Minister Albert Reynolds against the Times newspaper in 1999. The newspaper published an article claiming that Reynolds had misled the Irish Parliament. Reynolds sued for defamation, arguing that the publication damaged his reputation. The UK House of Lords, then the highest court, ruled the journalists could be protected from defamation liability if they acted in good faith and the publication concerned matters of public interest, even if errors were made. The publication addressed important societal issues rather than private matters. It was named Reynolds Privilege. Later, Reynolds privilege was replaced by the concept of publication in the public interest with the enactment of the Defamation Act 2013 in England and Wales. This new standard more clearly defines protection for publications serving the public good and does not require strict adherence to all the factors outlined in the Reynolds case. If you believe a media organisation has published false and harmful information about you, you have several options. First, file a complaint with a media regulator. For newspaper and magazines, IPSO provides an accessible complaint process. They can require the publication to issue a correction or apology if they find a breach of the editor's code for practice. For broadcast media, you can lodge a complaint with Ofcom. They can investigate claims of unfair treatment, privacy invasion, and false information. Both IPSO and Ofcom have specific guidelines on how to file complaints, and they may request evidence of the alleged defamation to proceed with an investigation. Second, consider legal action for defamation. You may pursue a defamation lawsuit if you believe the false statement has caused serious harm to your reputation. To succeed in a defamation claim, you must demonstrate that the statement is false, has caused serious harm, and does not meet any valid defences such as truth or public interest. Court action can result in compensation for damage, but it can also be costly and very time-consuming. Some cases may be resolved out of court if the publication agrees to retract or apologise. Thirdly, utilise online platforms reporting tools. If defamation occurs on social media or online platforms, you can use their reporting tools to flag the content as false or harmful. Most platforms, such as Twitter, Facebook and Instagram, have policies prohibiting defamation and harassment. Although their response times may vary, they can remove the content if it violates their community standards. UK law allows the press certain defences in defamation cases. Truth. If a statement is true, it cannot be considered defamatory. Honest opinion. The press is allowed to express honest opinions as long as they are based on factual information and are not meant to harm. Public interest. Journalists are protected if they publish a statement they reasonably believe is in the public interest, even if it harms an individual's reputation. These defences help maintain a free press by ensuring that reporters can cover significant matters without fear of litigation, provided they act responsibly. The boundary between free press and defamation is nuanced and can vary depending on the context. In the UK, the legal and regulatory framework aims to balance the need for a free press with protections against false information that harms individuals. For readers and those affected by the media, understanding this balance is essential. The media has a right to report, but when that reporting veers into defamation, individuals have protections and avenues for recourse to safeguard their reputations. By knowing your rights and the procedures in place, you can effectively navigate situations where the press may cross into defamation, ensuring accountability without undermining the vital role of the press. So, the next time headlines make waves, ask yourself, is it truth or does it tread on someone's dignity? Because accountability goes both ways. Where do you think is the line between free press and defamation? Leave your thoughts in the comments under this video. Hey, you! Yes, you! Are you enjoying these videos? If so, make sure you click the subscribe button and the like button. There's also a little bell. If you click that, you'll be notified when we have more videos to show you. Thank you!